In Vietnam, dealing with employee misconduct isn't just an internal HR matter, it's a regulated legal process. Many employers act quickly when faced with serious misconduct such as theft, insubordination, or absenteeism. However, even when the facts are clear, skipping a single procedural step can make the entire disciplinary action unlawful. The Labor Code protects employees by ensuring that every disciplinary decision is transparent, justified, and documented. For foreign invested companies, following the proper legal process isn't only about compliance, it's about protecting your company's credibility, management rights, and operational integrity. Employee misconduct in Vietnam is governed by the Labor Code and its implementing regulations on labor discipline. These rules define the lawful disciplinary measures available to employers, including reprimand, deferment of salary increase, demotion, and dismissal. Crucially, disciplinary action may only be imposed if the misconduct is clearly provided for in the company's internal labor rules, ILRS. Those ILRs must be properly registered with the Provincial Labor Authority to have legal effect. Without registered ILRs, employers have no legal basis to impose discipline. Even where misconduct is clearly proven, this registration requirement is the first and most critical compliance checkpoint before any disciplinary action is taken. 1. Identify and document the violation. When misconduct occurs, the employer must first document the incident clearly and immediately. Collect written reports, witness statements, emails, CCTV footage, or other evidence. The employee should be informed in writing of the alleged misconduct. The evidence must prove that the act violates a specific rule stated in the registered ILRs. Employers should avoid informal verbal warnings or undocumented decisions. Such actions have no legal effect. The goal is to establish an objective factual record before proceeding to any disciplinary step. 2. Investigation and review. After identifying the violation, conduct an internal investigation to verify the facts. This should be done discreetly but transparently, with fairness and respect for the employee's rights. If necessary, suspend the employee temporarily, up to 15 days, extendable to 90 for complex cases. While the investigation continues, such suspension must be notified in writing and clearly state the reason, duration, and salary arrangement during the suspension period. During the investigation, the employer must ensure impartiality. Decisions made without evidence, or based on assumption will not stand before authorities or courts. 3. Issue a written notice of disciplinary meeting. Before imposing any penalty, the employer must organize a disciplinary meeting. To do this, issue a written notice to the employee, their representative, if any, and the company's employee representative organization. The notice must be delivered at least 5 working days in advance, stating the time, place, and nature of the violation. This step ensures the employee has a fair opportunity to prepare a defense. Failure to provide proper notice automatically invalidates the disciplinary decision, even if the misconduct is serious. 4. Hold the disciplinary meeting properly. The disciplinary meeting is a formal legal procedure, not an informal HR discussion. Required participants include the employer's authorized representative, the employee, and the employee's trade union or employee representative organization, if any. The meeting must allow the employer to present evidence and give the employee an opportunity to explain or defend themselves. Minutes of the meeting must be prepared accurately, reflecting all key statements and evidence discussed. The minutes should be signed by participants present. If any participant refuses to sign, such refusal must be clearly recorded in the minutes. Without a properly conducted and documented disciplinary meeting, any disciplinary sanction, including dismissal, may be deemed unlawful. 5. Issue the disciplinary decision. After the disciplinary meeting, the employer may issue a written disciplinary decision. If sufficient legal grounds exist, the decision must reference the company's internal labor rules and clearly describe the misconduct, the form of discipline applied, and the effective date. The decision must be signed by the employer's legal representative or a duly authorized person. For foreign invested companies, the decision should be issued in Vietnamese or in bilingual form for internal clarity. A copy must be delivered to the employee and retained in the company's HR records. A disciplinary decision that lacks a legal basis, or reference to registered ILRs has no enforceable effect. 6. Comply with time limits and procedural deadlines. Vietnamese law sets strict timelines for disciplinary actions. Employers must issue disciplinary decisions within 6 months from the date of violation, or 12 months if the violation is discovered after an internal audit. Missing these deadlines invalidates the action. Additionally, no disciplinary measures may be taken while the employee is on leave, under medical treatment, or pregnant. These humanitarian provisions are strictly enforced, and ignoring them exposes employers to sanctions. Timing, therefore, is as important as documentation. 7. Final payments and post-discipline obligations. If disciplinary action leads to dismissal, employers must still complete final payments, outstanding wages, unused leave, and benefits within 14 working days. Failure to do so can convert a lawful dismissal into a compensation dispute. Employers must also ensure social insurance and personal income tax settlements are finalized promptly. Transparency in settlement shows compliance and respect for legal obligations, reducing the likelihood of claims. 8. Employer rights in disciplinary cases. While the law protects employees, it also recognizes the employer's right to maintain workplace order. Employers have the right to investigate misconduct, suspend employees temporarily, and impose lawful disciplinary measures. They may also defend disciplinary decisions before labor authorities or courts provided that all statutory procedures have been fully complied with. However, these rights are only enforceable when disciplinary actions are based on proper documentation and registered internal labor rules. LTS law advises employers to exercise their management authority confidently, but always within clearly defined legal boundaries. 9. Common mistakes employers make. Typical mistakes include applying unregistered or outdated internal labor rules, holding disciplinary meetings without proper written notice to required participants, firing employees without completing the investigation and disciplinary procedure, using English-only disciplinary decisions without a Vietnamese version, letting unauthorized persons issue disciplinary actions. Each of these mistakes can invalidate the disciplinary decision and expose the employer to reinstatement or compensation claims. Proper procedure is the most effective form of prevention. 10. Case example: how a procedural review saved a company. A Korean electronics firm in Bac Ninh discovered employee theft, but issued an immediate dismissal without following the required disciplinary procedure. The employee filed a wrongful dismissal complaint. LTS law reviewed the case and advised the employer to restart the process in compliance with labor law, including proper investigation, a disciplinary meeting, and a formal decision. Following the corrected procedure, the dismissal was reissued lawfully. The labor authority upheld the disciplinary decision. This case demonstrates that procedural compliance, not speed, determines legality in disciplinary cases. At LTS Law, we provide end-to-end legal support for handling employee misconduct in Vietnam. We assist employers in drafting and registering internal labor rules, preparing disciplinary documentation, advising on compliant procedures, and representing employers in disputes or inspections. Our bilingual lawyers ensure every disciplinary action complies with Vietnamese labor law while respecting workplace culture and HR best practices. Whether dealing with misconduct or performance-related issues, LTS law ensures your actions are lawful, defensible, and fair. Employee misconduct must be addressed, but in Vietnam, it must be handled by the law. Precision in process protects both your company and your reputation. Don't risk wrongful dismissal claims or administrative penalties because of procedural mistakes. Contact LTS Law today to review your disciplinary procedures, update your internal labor rules, and train your HR team to handle misconduct confidently and legally. Discipline with care and compliance under Vietnam's labor law.